The members of the General Investigating Committee have laid out the complaint process, the facts, and the arguments in this matter. They are compelling. And as stated clearly in the committee's report, the findings of fact are supported by independent and credible evidence. They are uncontroverted and unrefuted. To summarize, we found that Representative Slaton violated the House drug and alcohol policy by offering and providing alcohol to a minor, violated the appropriate workplace conduct policy by failing to abstain from harassment and other forms of inappropriate workplace conduct, violated the House rules by failing to report harassment in the workplace, violated multiple criminal offenses under Texas law, including the offense of furnishing alcohol to a minor, unlawful employment practice under the Labor Code, the offenses of abuse of official capacity and official oppression. As a member of the House of Representatives, he engaged in disorderly conduct under Section 11, Article 3 of the Texas Constitution. As a member of the House of Representatives, his conduct does not meet the minimum standards of conduct expected of a member. In sum, when all of these violations of policy and rules and law are viewed collectively and together, Representative Slaton has engaged in conduct unbecoming a member. No one in this chamber disagrees that this conduct was wrong. We all agree that it cannot and will not be tolerated. The housekeeping resolution and our committee rules require our committee to recommend discipline under these circumstances. Our bipartisan committee carefully and seriously considered all forms of discipline, and we unanimously recommend expulsion from the House. Now, some of you have wondered if a different level of punishment might be warranted. After hearing from Representative Spiller and Vice Chair Johnson, no one can conclude that we should simply levy a fine and be done. To do so would undercut everything that this complaint process with an independent investigation model stands for. Likewise, a piece of paper that says, "Don't do that," in effect a censure, just doesn't cut it. This Texas House is not going to hear from multiple complainants about serious and alarming facts and then casually turn the other cheek by slapping a member on the hand. Unfortunately, our rules and our laws in Texas, steeped in decades of tradition and practice, do not allow for a member to be punished in other ways, like being removed from committees, stripped of salary or seniority, or other practices that you sometimes hear about in other states or in United States Congress. So we arrive at expulsion. Section 11, Article 3 of the Texas Constitution states, each House may determine the rules of its own proceedings, punish members for disorderly conduct, and, with the consent of 2/3, expel a member. This provision is modeled on almost identical expulsion language in the United States Constitution. To quote a legal resource on the act of expulsion, the underlying justification for legislative discipline has traditionally been to protect the integrity and dignity of the legislature and its proceedings, rather than to merely punish an individual. Our Constitution does not determine what conduct warrants expulsion. There is no requirement that it be for a violation of criminal law. It is for conduct in which the judgment of the body finds that is inconsistent with the trust and duty of a member. Expulsion is rare. It occurs infrequently. Why? Because in most instances, members do resign from office, especially before a matter gets this far. You understand that, and I understand that. This investigation started with 3 complaints more than a month ago. Representative Slaton was provided timely copies of those complaints. He was afforded a due process hearing, all under the blanket of confidentiality. He had many opportunities to consider different outcomes. Finally, one day before today's resolution, Representative Slaton tendered a written resignation. Now, some of you have asked, does this mean that we don't need to consider expulsion? Our committee has provided you today on your desk with a detailed memo explaining that a member who has resigned is still a holdover in office until a successor is qualified. That's in the Texas Constitution. Right now, this means that Representative Slaton continues to receive his salary, continues to receive his constitutional per diem, continues to be entitled to receive reimbursement for expenses, continues to serve on committees, and continues to count as a member of this body for quorum and other purposes. Most disappointingly, the letter of resignation from yesterday shows no remorse. It contains no apology to those involved or to any of you. At no point in the last month has he ever demonstrated remorse or appeared apologetic in any way. Now, I've had the privilege of serving as a judge, and I've also represented defendants in court proceedings. Many of the laws that we mete out in this state allow us to consider a wrongdoer's acknowledgement that mistakes were made, that poor judgment was used, and that people may have been hurt. My experience has always been that leniency may be granted when one expresses regret, because each and every one of us is human and fallible. There is no apology here. No remorse. Resignation does not escape the need for this body to consider expulsion today. Members, this recommendation is not easy. There are no high fives, and it is not driven by politics. It is about the integrity of the House and the discredit reflected upon this institution. Hours upon hours, our committee members have toiled because you have asked us to do that. It is a decision that we did not arrive at lightly. After our committee report was printed and published Saturday, and our recommendation for discipline was made public to you, I received numerous notes from people, some anonymous, some from people that I know very well. All say something similar. I will read you one. Thank you for all the difficult and important work you are doing. I started working at the Capitol when I was 20. I worked for wonderful members who always looked out for me and made sure I was safe, but not everyone was so fortunate. Today, things changed in a way none of us ever thought they would. Members, at times during this process, I have wept. I have cried for all those involved, including Mr. Slaton and his family. I have cried for the witnesses. I have cried for the institution that I cherish. I have cried because I have the duty and responsibility to stand before you today and ask you to take this vote. My heart breaks. I suspect that yours does too. In thinking of this body and of Representative Slaton, I am reminded of a verse from Psalm 34. The Lord is close to the brokenhearted and saves those who are crushed in spirit. Members, I respectfully ask you to vote in favor of this resolution.
Does any member wish to speak against the resolution? The chair recognizes Mr. Murr to close on the resolution.
Mr. Speaker, members, I move adoption.
The question occurs on the adoption of the resolution. This is a record vote required by the Constitution. The clerk will ring the bell. So Ms. Johnson of Harris voting aye, Mr. Spiller voting aye, Mr. Longoria voting aye, Mr. Guerin voting aye, Mr. Murr voting aye. Show the speaker voting aye. Have all members voted? There have been 147 ayes and 0 nays. The resolution is adopted. The chair directs the Sergeant at Arms to bar the former member from the chamber. The chair directs the chief clerk to strike the former member's name from the roster of members and to notify the governor of the House's actions. The chair directs the voting clerk to strike the former member's name from the board. The chair directs the doorkeeper to remove the nameplate from the former member's desk. The House will stand at ease pending the completion of these directions.